thank you for participating in this. We think events like this are really a core and important part of what we do. The Tributary, just in case there are people watching who might not be aware, my name is Nichole Manna. I'm the executive editor of the Tributary. We are a nonprofit investigative newsroom. We are based right here in downtown Jacksonville in this building, the Jesse. And we focus on high impact, high quality work. You can see our journalism at our website, jackstrib.org. It is free for everybody. You will never be charged to see it. You don't have to be a member of something to access it. You don't have to log into something. We do have a newsletter you can sign up for, but you don't even need to do that to get our news. So tonight we are featuring a panel discussion that's going to be led by Nichole Manna. She's our senior investigative reporter. Last month she did a really incredible series called Cold-Blooded. It was about a death penalty prosecution of a Duval County man from the early 1990s. Those stories raised, I thought, compelling questions about the tactics that prosecutors used to get this man on death row, and also about the strength of the evidence that was deemed enough to get someone on death row. But looming in the background of that series is the fact that Florida is a death penalty state. And the death penalty, as it turns out, is a pretty complicated issue. And so we thought a broader discussion about the state of the death penalty in Florida would be a really good companion conversation to have after publishing Cold-Blooded. So I'm going to turn this over to Nichole. Thank you guys again for coming out. And my one modest ask is, if maybe you read Cold-Blooded, maybe you've read some of our stuff in the past, maybe you're going to sit through this event tonight and enjoy it, as I think you will. Tell a friend about us. Send the stories to the folks you know, your family, your coworkers. We're here, we're doing the work. That's my very small ask.
Thank you. Hi, I'm Nichole. I am the reporter of the Cold-Blooded series. I also got into print journalism because I have horrible stage fright. So please just bear with me tonight. But I want to first introduce you to our lovely panelists. First we have Herman Lindsey. Mr. Lindsey is an executive director of Witness to Innocence, an organization of, by, and for death row exonerees to empower them to fight to end the death penalty and reform the criminal justice system in the United States. Mr. Herman is the 135th person to have been exonerated from death row since the death penalty was reinstated in the U.S. in 1976. Thank you for being here. Huh? Man, I'm trying. I'm shaking up here. Our next panelist is a friend of mine, Melanie Kalmanson, who, if you read the series, you'd recognize her name because she is quoted in it. She is a commercial litigation partner at the national law firm Quarles & Brady. Before private practice, Melanie clerked for retired Justice Barbara Prenti on the Florida Supreme Court. Since her clerkship, she has published numerous academic articles and other publications on constitutional issues related to capital punishment, and she authors the blog Tracking Florida's Death Penalty. Highly recommend every single one of you sign up for it. It is incredible the work that she puts into this blog that simply tracks the death penalty in Florida. You'll learn a bunch. There's stickers for the blog outside on the table. So when I first started reporting on the Cold-Blooded series, I realized that I did not know much of anything about the death penalty, and I actually texted Melanie and I was like, hey, I'm working on this story. I don't know what I'm doing. I don't know anything. Can you please walk me through the death penalty? Tell me how somebody gets onto death row. Tell me what happens after somebody gets onto death row. So I kind of wanted to start there. If you could just kind of walk us through how we get somebody convicted of a capital crime and then on death row.
Sure, it's quite a long process, and generally the death penalty you'll find, if you keep reading about this topic or learn more about this topic, is more involved than almost any other criminal process in the country or in Florida. But generally, to make a long story short, once somebody is arrested and then charged with a capital crime, which until 2023 was first-degree murder for the most part, it had to be a homicide crime. Now in Florida, we have a non-homicide crime of capital sex crimes on children under the age of 12. That law went into effect in 2023. There are constitutional issues related to that legislation, but it remains on the books. Currently pending right now in the legislature is another bill that would further expand capital punishment in the state of Florida to other non-homicide crimes, specifically capital, well, they are calling it capital, but sex trafficking crimes against children as well. But you start out with an arrest, the defendant is then charged with a capital crime and goes through the general process of, being booked into the jail and the arraignment, so on and so forth. Within 45 days of the arraignment, the state has to file a notice of its intent to seek the death penalty in that case. It's completely up to prosecutorial discretion on whether to seek the death penalty against the defendant. So it's a prosecutorial decision whether they will seek the death penalty against each defendant on each count of first-degree murder or any other capital crime. So you could have a case that has, for example, 3 murders, and maybe the prosecutors decide to only seek death on one of those murders. And so the notice of intent is filed, and then the case proceeds through pre-trial litigation all the way up until trial. Fast forward to the trial process, and capital trials are bifurcated or split into 2 phases. In the first phase, which we call the guilt phase, the jury, which is always a 12-member jury, is asked to determine whether the defendant is guilty beyond a reasonable doubt, which if you've watched any crime show, you've heard that phrase. That decision under the 6th Amendment to the U.S. Constitution always has to be unanimous. So the determination of guilt or the conviction has to be unanimous. Once there is a conviction of a capital crime, so a conviction of, for purposes of discussion, first-degree murder, then the trial moves into the penalty phase. In the penalty phase, additional evidence is presented to the jury on what we call aggravation and mitigation. And that's, there are statutory factors listed in our capital sentencing scheme for aggravation, which is thought to make the defendant perhaps more deserving of the death penalty. An example of that is the victim was a law enforcement officer, or the victim was a child, or the capital felony was especially heinous, atrocious, or cruel. So there are specific factors within the statutory framework that are thought to make that crime more deserving of the death penalty. Under the 8th Amendment, the death penalty is supposed to be reserved for the worst of the worst, or the most aggravated and least mitigated crimes. In addition, in the penalty phase, evidence is presented of mitigation. And mitigation is thought to be something that makes the defendant less deserving of the death penalty. And that could be anything from the defendant's background, the defendant's character, anything within that defendant's life or situation or circumstances that are supposed to make the defendant or are presented to the jury as something that might make the jury think that the defendant is less deserving of the death penalty. There are statutory mitigating circumstances, meaning a list of circumstances within our statute, but then in addition, under U.S. Supreme Court precedent, the defendant has the ability to present anything that they want as mitigation, and it has to be considered by the jury. Once all of that is considered, the state has to prove at least one aggravating factor beyond a reasonable doubt for the defendant to be eligible for the death penalty. That finding has to be unanimous. Once that happens, the defendant is eligible for the death penalty. After that, the question for the jury is the appropriate sentence here life in prison without parole or death? And the jury then weighs the aggravation and the mitigation and makes a recommendation on the sentence. And that's an individual determination by each juror. Under Florida's current capital sentencing scheme, the trial court can sentence the defendant to death so long as only 8 of the 12 jurors vote to recommend death. And that changed in April 2023. Before that, we had a unanimous recommendation requirement. Florida currently has the lowest standard for imposing the death penalty in the entire country. There are only 2 states in the country that do not require a jury's unanimous recommendation for death, and that is Alabama and Florida. Alabama's requirement is 10-2. Every other state requires a jury's unanimous recommendation for death. And then after the jury returns its recommendation recommendation. If the jury recommends death, then it's up to the trial court to make the final sentencing determination, and the trial court can depart from the jury's recommendation, but must explain in writing why it did so, or it can follow the jury's recommendation and impose a death sentence. That's a very long process in a short period of time, but that sums it up for purposes of our discussion, and I'm happy to answer more questions.
And then from there, of course, we go into an automatic appeal if somebody is sentenced to death row. And from everything I've understood from people who are on death row, how it's really difficult for one here to talk to your attorney. And it almost seems like people who are in prison become attorneys yourself. Can you walk us through, when you're on death row, was it difficult to get in contact with your attorney? How did your appeal go?
Well, I personally got lucky. I had one of the best attorneys in the world. Excuse me if you're an attorney. But it's very difficult once you got convicted, because it's something that you're facing that you didn't want to face, especially when, in my situation, where I was actually innocent of the crime, and I still got convicted. So I lost faith. Because it's like, how can you believe in the justice system that just convicted? And that attorney is part of that justice system that works. So it makes it seem like the attorney is against you when we don't really know about the law. We don't understand that the attorney did fight for us, but the attorney did make the best choices and strategies for us. It's just that, things went the opposite way. And the reason I say my attorney was one of the best is because my attorney communicated with me. He asked me how I felt about the motion he was filing, or, if we should file this motion and why he believes we should file it. So I understood it. But what is also, my lawyer encouraged me to look into the law, read some of the stuff so you can understand it. And that's what makes it so difficult for some of your attorneys, because we have individuals that look at the law and interpret it in their own way and become jailhouse attorneys and give their attorneys hard times, or mislead others to believe that their attorney is not what he wants.
Were you able to talk with the other men who are on death row regularly to get their input on what was happening? And can you, tell us what was day-to-day life like?
For me, I mostly slept until Reba came on. When Reba came on, I get up, I watch Reba on TV. I lay back down. But a lot of times, we go out, we play basketball together, we communicate together. And one thing about the individuals on death row, it doesn't matter what race you are, what religion you are, we are all one. We all family. And once you're in that space, it's like we know, we feel that we are doomed, and that all we have is each other.
How were you able to keep up your faith and your hope, knowing that you are innocent in the position you're in?
Watching people.
Okay, so Nichole Reba, we can get her here.
You have to look at it. In my case, I didn't know much about appeals. I didn't know about appeals, and I'm looking at so many people going years and years on appeals. So I'm like, I have an innocent case. I'm innocent, and I have to spend all these years and years through appeals. That's the way I'm thinking. So some of the guys, we comfort each other and talk about it. When they see my oral arguments on TV, and they was babbling and got me up, to amaze me, and this is what changed my life, to say, I don't know if fight for justice is just forensic, was up there arguing with the state for me. And you never seen a judge argue about, and it wasn't necessary for me, but it was, we have to follow this law. And it's like, that let me know it's people that's actually in our justice system that's good, and that will actually fight for you. It's not just because you, a young defendant, poor and came for an attorney, that everybody wanna just lock you up and throw you away, some actually fight for what is justice.
And you brought up a point about the appeals process. Can you talk a little bit about that, Melanie, and why does it take so long for that process? And when we go back to the Cold-Blooded series and we looked at Kenneth Hartley's case, he's been appealing his case since 1993, and he's still on death row. Why does that take so long?
Sure, so kind of starting where we left off in my prior explanation of the process, once a death sentence is imposed, then the defendant is taken to death row, which is actually not too far from here, if anybody didn't know that. And there's an automatic direct appeal. And what's different from a death sentence and a life sentence is death sentences in all litigation related to any death case in the state of Florida go straight from the trial courts to the Florida Supreme Court. Any other case, if you were to file a civil lawsuit or if the defendant were to be sentenced to life in prison instead of death, would go to our intermediate appellate courts called the District Courts of Appeal. So under our Florida Constitution, the death litigation or the capital litigation goes straight to the Florida Supreme Court. So once a defendant is sentenced to death, then the notice of appeal is filed to the Florida Supreme Court, and that direct appeal goes straight to the court, no matter what. That's automatic. A death sentence does not become final until at least certain appeals are finished, including the direct appeal. Related to the length of litigation on a death sentence, Herman was very fortunate in that his sentence was vacated on direct appeal, and it was 18 months, is that right? It's about 18 months. Generally, when we see exonerations or post-conviction litigation, it's decades. If we look at our most recent exoneration, I think we'll probably talk about that in a little bit, it was over 30 years before he was exonerated. After the direct appeal is completed, then the post-conviction process starts. And there's an initial post-conviction motion which starts in the trial court and then again gets appealed straight to the Florida Supreme Court. And then a defendant can raise what's called successive post-conviction motions, essentially at any time that they have a claim. There are very specific rules and time limits on those post-conviction motions, but I've seen people on death row who have raised 13, 14 successive post-conviction motions before either an execution or natural death. So it really just depends how the case proceeds and what the ultimate outcome of those appeals are.
And speaking of exonerations, am I correct that Florida has the most death row exonerations? Why is that? Is there a simple answer to that question?
I don't know the answer as to why. We have 30 Florida death row exonerations since 1976, and we all keep saying since Florida reinstated the death penalty. What happened in 1976? That's when the death penalty sort of restarted in the modern era after the U.S. Supreme Court decided Herman v. Georgia. So that's sort of what we all, when you talk about the death penalty, that's the starting point for everything. But Florida has 30 exonerations from death row since that point, and it is the most in the country. Now, it's sort of misleading to say that. It's true, we have the most exonerations, but we don't necessarily proportionately have the most compared to how many death sentences we've had, right? So we've completed 109 executions since 1976, whereas Texas has completed almost 600. And Texas has 18 death row exonerations. So it's sort of like, and this is something that I haven't studied, we have the highest number of death row exonerations, but I haven't done the math to see like proportionately how do we compare to other states compared to the number of death sentences imposed, the number of executions, so on and so forth. One thing that is interesting, that you'll hear a lot if you do some research into this, is that I think it's every single exoneration except 2 of ours, Herman, correct me if I'm wrong, those death sentences were imposed after a non-unanimous jury recommendation for death. Of course, that's also sort of misleading because you always have to have the unanimous recommendation or the unanimous conviction. So the jury was always unanimous on the conviction, but it is interesting that those juries were always non-unanimous on death. And so that means that they were also imposed prior to 2016 when our law changed. But either way, we've gotten it wrong more than any other state.
I would just like to point out this too, because a lot of people look at we lead the nation in exonerees as a bad thing, but I like to also look at the positive thing because there's so many attorneys now that's actually getting involved in the innocent claims. Because if you go years back and someone do an innocent claim, most attorneys don't touch the case. But now we have attorneys that take the time out and organizations rally up, and we got advocates, and we have a great system down here that goes in and pull those innocent people out. So we also got to tip our hat to the positive side of that also.
And to Herman's point, right, it could be that there were innocent people who were executed in, for example, Texas. If you watched the movie Trial by Fire, it's sort of about a case where that might have been possible. We don't know how many innocent people might have been executed in other states that may have changed those numbers as well, so.
So is the appeals process different depending on what state you're in?
The appeal process is specific to, the procedure is specific to the state, yes. There's always certain federal claims, and the federal process generally remains the same, but the state process is different.
And is it usually people being exonerated because of innocence claims, or are there other types of exonerations? Thinking, for example, again, going back to Kenneth Hartley's case, I don't think right now his attorneys are making an innocence claim. Can you walk through what other claims can be made in cases like this?
So this is, I think this gets into a lot of technicalities and nuances, but I can speak sort of to this. I think your question more technically is, does there have to be a finding of actual innocence during exoneration?
Yes, thank you.
The answer there is not necessarily. Generally, you're going to be raising a claim related to innocence and a finding related to something like in Herman's case, the court found there was not enough evidence for his conviction. But the way to get to that answer might be different in every case. Like, for example, I worked pro bono on a Texas case, and the claim there is based on DNA evidence. And under Texas law, the standard for proving an entitlement to relief on that claim is different than proving entitlement to relief on an actual innocence case. So they're all related to an innocence type theory, but the standard might be different, if that makes sense.
Melanie, Terry thought, the thing about Texas is the trial court judges sign the death warrants. As you well know, I'm sure, in Florida, we just have the governor and the governor's staff reviewing. But Texas, there's 467 judicial circuits, and all of those judges can sign a death warrant. That's why there's so many executions.
Yeah.
If I may comment, you mentioned the Hartley case, and he's been fighting since 1993. Hartley case is very, very much similar to my case. We had a person that came up and said that I was in a holding cell with him and I confessed it. That's the only evidence the state really depended their case on. Luckily, I was able to have an incident where he was placed in the holding cell, and he was placed in the holding cell with me and 35 other inmates. And I think it was 4 officers and a lieutenant was there, came in, and they heard him talking to me and admitting that me and him never had this conversation, that he didn't know me, and he was explaining that the police was making a deal with him to get his time cut off because he was actually the prime suspect in the case. At the beginning, we actually had evidence that a guy named Eddie Carter said that he was walking around bragging about killing the lady in his case back in 1994. And I was arrested 12 years later before this, based on his statement. So, my case is very, very similar to that, and I think, my opinion, that a lot of these innocent cases is around jailhouse informants. I think those actually should be thrown out.
Yeah, that was a question that I had for you, specifically jailhouse informants. How often do we see those in capital punishment cases? And what would compel somebody to make up such an egregious lie that it could end somebody's life?
I mean, I've seen the case numerous of times. You know, even the state attorneys these days, I've seen where in Broward County, state attorneys will put individuals in the holding cell with a person just to obtain information. They come back and get partial information, and they come back and make a whole story of it, like they actually did it. And because they can name some type of, like for instance, when we in the holding cell, you know, the roommate is there, your discovery is right here. A person can look through your discovery and see some things. Maybe I'm out the wreck, he didn't want to go to wreck. He's looking at my discovery. Now he has information to feed the state attorney to say that, yeah, I told him this, I told him that, but in reality, I did not tell him that. You know, so, and they rely on that heavily. They rely on, the state attorneys rely on it heavily, and I think that's something that should be barred.
How do you protect yourself from that?
I mean, on death row, we are held singly, and we each own have our own cell, and one of the rules, number one, is do not talk about your case, and two, don't ask somebody about the case. And the thing about it, when you're housed in county jails, there is no protection from that.
And you have access to media, right? You have newspapers, you have a TV.
Media will put certain things, but if I look at the discovery and I see a police report and it's describing how it went, and the police doesn't release that information, it seems like I know, like you actually told me, and that's how easy it is to convince a person that's on the jury. You know, a person on the jury would say, well, how did you know that the person was on fire? The police never told that, and the state attorney gonna make it, and it's open or his closed, he gonna make sure he point that out, that, we did not release this information, so how did this defendant know? So he gonna amplify that person's, statement to their advantage.
And you say you had your discovery. Can you just explain what discovery is? And then I'm assuming there's no place in a local jail to hide that. So it's just out in the open?
It's out in the open, and if you go out to red, anybody can come in your cell. Because a lot of times during the daytime, they leave the cell doors open. And as they leave the cell doors open, if you go out to recreation or you go out to medical, you have no way to protect that. And most of the time, it's boxes of discovery, so you can't get a luggage on the back with you. So, the jail should put some type of protection in on that, but there's no protection from that. There's no protection.
And you obviously work with exonerees. You talk to them, you hear their stories. How often do you see jailhouse informants being used, and especially in your case, being the only evidence that's used?
It's a lot of cases. I mean, here it is, I was convicted in 2007. Hartley was convicted in 93. It's basically the same thing. The same thing. I think that, and she was explaining the difference in the district courts and the Florida Supreme Court. We believe that us facing the death penalty, we believe that we want a death sentence, especially when you're innocent, and it's because you get a better review. And the thing about it is, it all deterred, not to disrespect the Florida Supreme Court, but sometimes we have bad evidence in this Florida Supreme Court. And if my case was in front of another one, I might have just ended up with a new trial. You know, I had justices up there that was going by the law and father. A lot of times you don't, especially in Texas. Especially in Texas. Texas is one of the worst places it is. Oklahoma. You know, I'm over an organization that has to deal with the death penalty in all states that has the death penalty. So I know about all of them. And it's the same thing, we may have actual judges in that appeal that will not give any type of relief.
And Melanie, coming in as an attorney when you're looking at a case and you see the use of jailhouse informants, what do you do with that?
So I personally have not worked on a case with a jailhouse informant issue, but generally, it's an issue that you look at in these cases. They're an issue, like Herman said, they haven't gone anywhere in several years. There's a lot out there on the unreliability of jailhouse informants, and to your question earlier, why would somebody do that? It could be a deal with law enforcement, it could be a deal with prosecutors, it could be to save themselves from prosecution for the same crime. You know, if they know that they committed the crime, but police are looking at somebody else, why not, right? Keep the attention on somebody else. So this is an ongoing prevalent issue in our criminal justice system.
And I've seen some states recently passing legislation to tamper the use of jailhouse informants. Kansas, for instance, is looking at legislation where the state attorney's office would have to track informants. So you would know if they're being used over and over again, which we're seeing when we're looking into death penalty cases here in Duval County. We're seeing some of the same names pop up. Does Florida have any legislation to do the same? And what could the legislation look like to make this issue not as pervasive?
I'm gonna chime in on that. Because that's not possible. And the reason it's not possible because the state attorney is like have more power and resources and ways around it. I see them use informants on the streets, and they will send an informant in there to buy drugs and come out. The informant may not have bought drugs out there, but in the reports it would say they searched the person before they went in there. So actually tracking the police department, you know, you might have some that play there and actually track, but that definitely would work.
It seems like everything is up to the people who are in charge. Like, the future of your case depends on who's on your Supreme Court. The future of your arrest depends on the officer and the police department. It's just kind of up in the air.
There's a lot of discretion in the capital sentencing process generally, right? So the same case could be prosecuted in Duval County and Palm Beach County, and the prosecutor in Duval County will seek the death penalty and Palm Beach County won't. So that's prosecutorial discretion. That's the first discretionary step. You know, there's a lot of discretion in the process and a lot of changes in the process, and I could go on and into the details of how our laws have changed over the life of Kenneth Hartley's case, for example. Our law has gone from requiring a 7-5 jury recommendation to unanimous and back to 8-4. So there's a lot of changes and a lot of discretion in a situation that is literally the difference between life and death.
And can you tell us how Florida stacks up recently in the last few years, especially under the DeSantis administration? You have written a lot of op-eds about his views on the death penalty and the warrants that he has signed. Can you talk a little bit about that and where we are this year with the death warrants he has signed?
So, as I said earlier, we have the lowest standard for imposing the death penalty in the country. That's as of 2023. Before that, our law changed in early 2017 to require a unanimous recommendation for death, and that essentially brought us into line with the rest of the country. When that change went into place in April 2023 was essentially a legislative reaction to the Parkland shooting trial, where the shooter did not get the death penalty because the jury did not find that the aggravation outweighed the mitigation. And DeSantis very much supported that change in the legislation. And there's legislation pending now to, like I said earlier, further expand the scope of capital punishment in Florida, but also expand our capital sentencing scheme more broadly to include more aggravating factors, which would make eligibility for the death penalty easier. There's also legislation pending that would expand the state's ability to use new execution methods. If you've been following the news, you've seen Alabama and Louisiana are now using the gas execution method. Florida is now trying to make sure that they have legislation in place that would allow them to use any method that has not been deemed unconstitutional. As far as executions, Florida for a long time has been one of the leaders in maintaining and continuing executions. Every year it's essentially a handful of states that completes executions, and Florida is generally among them. This year we're continuing at an unprecedented pace. In 2019, the beginning of DeSantis' administration, there were 2 executions in the state. There was then a hiatus for COVID, and DeSantis stopped signing warrants during his re-election campaign, and that's what he said in the news. I'm not speculating. He has said that's why he stopped. And then in 2023, executions resumed. We had 6 executions. In 2024, there was only 1 execution, and this is speculation on my part. I think it had to do with perhaps his presidential run, but I'm not sure. He never really explained the reason for the pause, or at least the slowdown in the executions. But then in 2025, he is back at an unprecedented pace, and we have completed 3 executions so far this year, with 2 more scheduled. There's 1 scheduled for May 1st and 1 scheduled for May 15th. So we are leading, we're right up there at the top this year so far in 2025.
And is there any way to tell why he signs a warrant on the cases he signs? So no. And what happens when a warrant is signed? What are the next steps?
Unfortunately, no. So, like Terry commented earlier, every state has its own process. So in some states, the trial court signs the warrant. In other states, the governor signs the warrant. In Florida, our governor signs the warrant, and it can happen at any time, so long as the death sentence is final and certain appeals have been completed. So there are 273 people on Florida's death row right now. So long as they are warrant eligible, the governor can sign a warrant for any of those people at any time. And about half of our death row prisoners are warrant eligible right now.
What does that mean?
It means that they've completed the appeals necessary before a warrant can be signed. And so Governor DeSantis can sign a warrant for anybody at any time with no notice. So you can be sitting on death row for 35 years, as a lot of people have been, and then one day the guards come and tell you that a warrant has been signed, scheduling your execution for 28 days from now. Generally, the warrant periods in Florida range between 28 and 31 days as of late.
And so the guards tell you that. What happens next? Do you get an attorney? Does it go into an appeal? How does that 28-day time frame look?
So it's called the warrant period, which is the time frame between the warrant being issued and then the scheduled execution. So I'll use Jeffrey Hutchinson, for example. His execution is scheduled for May 1st, and I believe his warrant period is around 30 days. When a warrant is signed, it is sent to back up. There's always counsel appointed for everybody on Florida's death row, so they don't have to go out and find a new attorney when the warrant is signed. There's always somebody assigned as counsel for everybody on death row. So the warrant would be served to the attorney for that prisoner, as well as the guards at Florida State Prison and Union Correctional Institution, which is where death row is housed right now. Once the warrant is signed, then the guards at UCI, the prison, go and serve it on the prisoner. At that time, the prisoner is taken from his cell and moved to Florida State Prison, which is just down the street from UCI, and put on what's called death watch. So they're actually moved to a different prison, to a separate area of the prison, and they're held there for the remainder of the warrant period until the scheduled execution, unless there's a stay or the execution is canceled for some reason. And that's where they will stay for the remainder of the warrant period. And then there are different phases to the warrant period in the death watch process. And what usually happens within that 28-day period or 30-day period is the prisoner will file a new post-conviction motion, like we talked about, in the trial court. The litigation has to be completed within the trial court, usually within 7 to 10 days. And that includes if the trial court finds it necessary, an evidentiary hearing, any case management, everything related to litigation of that claim, full briefing, and the final order. Once that final order is issued in the trial court, the appeal goes automatically to the Florida Supreme Court, as in any other situation, and then full briefing at the Florida Supreme Court as well. And then after briefing at the Florida Supreme Court and a decision by the Florida Supreme Court, the prisoner will often seek a petition or file a petition for writ of certiorari at the U.S. Supreme Court. And all of this has to happen and be completed within that 28-day warrant period. So there's no other context, in my knowledge, where a claim like this, or any claim, is litigated so fast in so many different courts at different levels. I mean, the briefing schedules are, I don't know how they do it. I mean, I think about everybody who works on a warrant, whether you're representing the state, representing the prisoner, they're not sleeping.
Wow. And Mr. Herman, when you were released, to switch gears, when you found out you were being released, what happened? How did you find out that was happening, and what were the next steps? Were you still held in prison for days, or were you released immediately? And how did you reintroduce yourself back into society?
Well, first of all, I was able to see my own arguments on TV, and the way the Florida Supreme Court reacted, I think one of the key things was that they took the informant word over for officers that sworn to uphold the law. The officers testified that they heard it, so he never had that conversation. And that I didn't never tell him that, and that he was making a deal with the police. So once I seen that were arguments, I felt that something was going to happen in a positive way. So I was at one day I was at my cell, and actually I was watching Reba. Reba come on 4 times a time.
I'm telling you, we want to find Reba, we have to call her.
So the psychologist and the lieutenant come to the cell, and they telling me they have to take my TV in my pen. And the only way they take that is if you get a disciplinary report. Death row is miserable if you don't have the TV to watch and your fan because it get real hot.
There's no air conditioning on Florida stuff, right?
No. So I was like, why? And they waited till I got to the credit to say, because I kept saying, man, I ain't get it. Now, where the paperwork? But I ain't got no DR. And then they had me the paperwork with the Florida Supreme Court people. And I just dropped to my knees, and I kind of cried, From that moment, I had to wait 14 days before I was released because the state has the option of appeal the Supreme Court decision, and they waited to the last day to actually release me. And once I was released, because the news media was outside the prison, the warden decided to put me back on the van, shackle me, and drive me 5 hours down to Martin CI and release me to my parents in the parking lot. So they took the shackles and stuff off me once I got there. And from there, I rushed my mom down by the parking lot to go to McDonald's and get milk. I'm serious, though. I'm
That's
sorry.
your next question was, what did you need first? Tell us your full order.
After that, I didn't know where to go with life. I was torn. I was shielded up. In fact, today I'm still shielded up. Most of the time when I'm home, I'm like still staying in my room. My wife was just talking to me about that the other day. Why you stay in that room so much? And it's like I was asked the question, do you ever find yourself being reminded of death row? Yes, I stay in my room all the time. I don't too much go out. I travel a lot. When I'm traveling, I go speaking events. I go back. It's just something that has done to me. Before I went there, I was an outgoing person, but now I don't like being around crowds unless I'm speaking, and then I'm gone. When I got out, I didn't want don't speak, but, Mark Elliott from FADP, tricked me. I call him my papa now because he's been like a father to me, the best person that's been by my side since I've been home. So Mark, if you're watching, I said papa, okay? But I didn't want to speak. And then Mark was telling me, well, we can give you an honorarium. And I just went to the mall and I see the joints I wanted. So I went ahead and agreed to start speaking. And then once I made the speaking, and I realized that people really don't know much about this situation. You know, I feel like it's my obligation to go out and speak. And today, it is a great toll on me how my life is, because I have so many boundaries still because of that same murder charge. I still pay the consequences of that. You know, I mean, I sympathize with those that spent 35 years. You come out 35 years, I'm 52 years old, I want to buy a house. But I can't make those tax credits that I missed, or those people missed, to be able to say when I'm 65, I'll retire, I can get my Social Security. You know, I just applied to do Uber driving the other day, and I got denied because of this murder case. It's on my record, even though I was paid. It's so much, but you know, and I stay in a trauma shell, and it's like you can't get. I made good money on my job, so paying for insurance is very expensive. Very expensive. I moved. Don't throw no rocks at me, but I moved from Florida to Georgia because it's cheaper up there. And I finally got insurance, but I went for years. I wasn't able to see a psychiatrist. I didn't get compensated. I didn't get no apology.
What else were you able to do in Florida? What else were you able to do in Florida?
I mean, I didn't get my voting rights. And I've been out 15 years, I haven't my voting rights. I go to Georgia, change my license over to Georgia, I automatically vote. I automatically vote. You know, it's just damage. I'm gonna leave that alone because I'm starting to get emotional.
Thank you for sharing. Thank you for being here. I want to make sure we have time for questions if we have any. Nate has a question.
I don't, but I forgot to mention, we do have a good number of people watching the live stream. If you have a question, if you type it in the comments, we'll get it recorded and we can ask it. And then folks here can just kind of shout it out. Just don't ask a weird question. I will get us started though. One of the, there's a concept in Cold-Blooded about Brady and Brady violations. And Melanie, I was wondering if you could talk to us a little bit about what that is and, you know, the prevalence of it in death penalty litigation.
Sure, so Brady was a decision from the U.S. Supreme Court. And essentially what the rule is that the state has an obligation to overturn discovery to the defendant that would be helpful to the defendant. And I'm going to simplify this, so if the attorneys in the audience want to correct me, please go ahead. If later on, after trial or in post-conviction, it is discovered, like it was in Hartley's case, that there was something that was not turned over to the defense that they should have had at trial, then the defendant can raise what's called a Brady violation, that the state did not honor that obligation and did not turn over the information to the defense. And that claim is then litigated like any other claim. It starts in the trial court. There might be an evidentiary hearing. If it's denied, or even if it's granted, then either side, the state or the defendant, can appeal it to the Florida Supreme Court. The trick with a Brady violation is you have to be able to show, the defendant has to be able to show prejudice, meaning that it would have made a difference had the information been disclosed. So that's Brady in a nutshell. If you have a further question, I'm happy to discuss. And then I also wanted to add my explanation of the warrant process. What I didn't explain is what happens on the inside of the prison. So while everything is happening in a very, very fast pace on the outside of the prison in the courts at all different levels, there's also a preparation process that happens inside the prison. So the prisoner is moved from UCI to FSP and housed on death watch like we talked about. And then certain procedures are in place to prepare the prisoner for the actual execution. There's 2 phases to the death watch process, like I talked about, and there's actually at one point in the death watch process, a guard will sit outside the death watch cell for 24 hours a day taking notes about the prisoner's actions. And one part of that is to make sure that the prisoner does not die by suicide while on death watch. And then also throughout that process, I believe like a couple days before the scheduled execution, they will start taking the prisoner's belongings away from him to prepare for the execution. The day of the execution, the prisoner is woken up fairly early. The past few executions, they've woken up around 4 or 5 in the morning. They're given a last meal, I believe right around the time they're woken up, but I'm not exactly sure. And they're allowed to choose their last meal, and this is state specific, every state has their own procedure. Florida allows the prisoner to choose their own meal, but it has to be prepared within the prison, and they have a budget of $40. So everybody always asks, you know, what would be your last meal, or, and it's a terrible thing to ask somebody. Don't talk to me about the stories that I have when somebody has asked me that, but nobody really realizes the reality of it, and the parameters that are put on that process. And then there are visits that are allowed throughout that day, and then the prisoner is prepared for the execution, and witnesses are allowed in Florida at the execution, both family and friends of the victims, members of the public, and members of the media, but we do not allow family and friends of the prisoner. Other states do, but Florida does not.
Do you know where that is?
I don't.
Can I ask a question about the use of jailhouse informants during trial? What are they required to reveal about what they're receiving in return for their testimony? And are they required to reveal anything about how many times in the past they have been used as an informant by law enforcement?
In Hartley's case, the jailhouse informants were asked about their deals. I think that's pretty common and standard from what I understand. In his case specifically, they said that they were still facing upwards of 15 to 30 years. In reality, none of them went to prison. 2 of them were let out on time served. And then I believe one just did like a global jail stint, so a sentence of under a year. So in his case specifically, I think the way that they were able to get around that was by saying upwards of 15, upwards of 30. But that has been one of the issues that his attorneys have brought up in his like current appeals.
And that would go towards the Brady information that we talked about. It would depend on what information was given to the defense, what information came out at trial, and then what transpires after trial.
Well, I just asked because if somebody is used over and over and over again as a jailhouse informant, can you bring that up in trial? Can the defense attorney bring that up in order to impeach that witness?
Yes, all of that would be,
Sorry. No, you go, you're the attorney.
all of that would be fair game on cross-examination, assuming the defense attorney has the information.
Yeah, in kind of Hartley's case, which is the only case I could talk about, and barely at that, there was questions about one of the jailhouse informants, Ronald Bronner. We learned later, his attorneys learned later, that he had been used in cases before that. So that's another one of the Brady claims that was never disclosed during the trial. He was actually asked, we have the transcript, we've read it, he was asked if he's helped the state attorney's office before, and he said no.
Let me just say something about that, Terry, stop. I've been doing this for 46 years. Now, this jailhouse informants, in 2001, there was a Florida Supreme Court commission on the death penalty because there were so many cases like Hartley's. And that went around the state and got proposed rules. And one of the rules that came out of that entire statewide hearing process, which was, we can thank our local attorney Hank Cox here, because he did it, he pushed it through, was that the state now has to provide all of that information about a confidential informant. But one of the tricks that we ask confidential informants is when they say, oh, I fully expect to get a prison sentence. It's like, okay, well, what are you gonna do about your lease and your mortgage and your dog and your car? Have you made those plans? Have you done that? We also subpoena all the records of payment. The sheriff's office that pays confidential informants, they have records of payment. All that's subject to subpoena. So there's plenty of ways to do it. It's just that it takes a while to think of it and bring it up. And back in the old days, you know, nobody really did that. But it's gotten better now.
Yes, sir.
The composition of the Florida State Supreme Court is elected, appointed. I see a lot of what the governor has appointed as members of that Supreme Court. What is the protocol? How many serve? Could the governor stack the whole deck so that as you go through an appeal, since that's the place that it goes to, what does that all look like?
Great question. Florida has a merit selection and retention process, which means that we have a judicial nominating commission. They review the nominees, they do, the commission does interviews with the nominees and then ultimately make a recommendation to the governor, and the governor makes appointments to the Florida Supreme Court.
But the judicial nominating committee then is formed in what manner? How do you start?
By the governor.
By the governor.
Okay, so.
Yeah, it
used to not be.
It's not the best process. I've written articles on judicial independence as well. But elections also aren't great either, right? Other states have partisan elections and we don't want our judges doing that either. We also have merit retention elections in Florida where you probably see our district courts of appeal judges on the ballot and you have no idea who they are and you vote yes or no, just Christmas treeing it. We also have Florida Supreme Court justices who are up for merit retention, and that's not great because we've seen attacks against them as well. So it's not a great system. There are other better systems for sure, but like you said, Governor DeSantis can stack the deck. He absolutely has placed a lot of our justices on the current Florida Supreme Court because the 2019 or 2018 gubernatorial election was very critical for the Florida Supreme Court because 3 justices retired that year. That was when my justice retired. And the next governor, who ended up being Governor DeSantis, got to appoint those succeeding justices. And since then, there's been a few more turnovers. So the court that we saw in 2016 is a completely different court than we have now in today, or even that we saw in 2020. And there's been a lot of cases and a lot of law overturned in capital punishment arena due to the change in the court. And not gradually, but blatantly overruling prior Florida Supreme Court decisions. The change that I talked about earlier with Florida having a unanimous recommendation for death, that was a requirement by the court per an October 2016 decision in Hearst v. State. In 2020, after the change in the court in 2019, the Florida Supreme Court overruled that determination and said a unanimous jury recommendation is not required. And there's been other changes like removing mandatory proportionality review on direct appeal, removing relative culpability analysis. There's been a lot of changes from this current court.
And they're all bad.
It depends what's under.
Do we have any other questions?
I have a question for Herman, and
Yeah.
I keep talking, but
Please.
Herman, you heard what I said about, I handled everything from reckless driving to death penalty cases. Tell me what I need to do to make my clients in the jail stop talking to other people and stop talking on the telephone about their cases. Tell me, please.
Tell me to watch Regal. No, okay, so the thing about it is that when you're a defendant, it's a lot of times you're scared. and you have someone that they don't just talk to anyone, they just talk to someone that they feel confident and has knowledge of the law, or been through that system, been in the system before. It's been a lot of cases where the phone records are being used nowadays, and a lot of these guys don't understand. And the most major part is when you're first arrested. When you're first arrested and you're being booked, and that one phone call you give, you go to saying stuff that you shouldn't say. And a lot of them don't know they're not supposed to do that. A lot of them aren't supposed to know they do that. But some are just dumb. You know, I mean, I hate to say it like that because I have a brother right now that's in prison, and when he was going to court, when he first got arrested and thing, and I told him, I said, he tried to talk to me on the phone, and I tried to cut him off. My family, for some reason, my family feel like I'm a lawyer. They feel like I'm a lawyer. And when it comes to legal things, they ask me about it, they feel like I'm a lawyer. And every time he tried to explain to me what it, I said, leave it alone. I see the police report. You know, just don't talk about it on the phone. And he'd get off the phone with me because he didn't get the answers that he wanted, and get on the phone with my mom and start talking. My mom would tell him to shut up. So he'd get on the phone with somebody else until he find the answer. And it's just a way that you're trying to feel to feel secure, or until they reach that point. You know, you did the crime, you're not going home, stop trying to plead your case until, you know, you get a chance. So, I don't know. Then you could take them, I'm telling you, if you let them sit there around people there.
So, an idea in terms of percentages of individuals who are on death row, represented by private attorneys, represented by PDs. What if you're looking for a private attorney? How much money do you have to come up with up front in order to do that? And then lastly, if you're exonerated, Herman, does the state compensate you in any way for that lost time? If you, in fact, had a private attorney that you paid out of pocket, will they reimburse you for those expenses that you incurred?
No. I'm gonna just do the conversation real quick. I'm gonna get out of the way. That's your department. The conversation. When I got out in 2009, I was eligible for compensation. However, we have a bill for compensation in the statute. However, it's two problems with that. One, if you have a prior convicted felon, if you a felony, you didn't qualify for compensation. And I had a felony when I was 14 years old. It had nothing to do with what I was arrested for. Second, to meet the prong of the compensation bill, and judges was going crazy. I had judges Rodriguez down in Broward, and she was wondering, what is this? You have to go back and petition the lower court to prove your actual innocence.
So I'll add to that and then I'll answer your other questions. Robert Dubois is our most recent exoneree in Florida. He's our 30th death row exoneree. He was exonerated in 2020 out of Hillsborough County. I looked this up last night. After 37 years in prison based on mainly DNA evidence. He was sentenced to death by jury override, which we don't have anymore. But what that means is that the jury recommended a sentence of life in prison and the trial court sentenced him to death anyway. In April 2023, he was given $1.8 million for his 37 years on death row.
However, that wasn't a compensation under the compensation bill.
It was separate.
It was a lawsuit. See, in some cases you have such much damage in the investigation that you could actually sue the police department. You cannot sue the judges. You cannot sue the state of Florida. You cannot sue them. So his case was won, I think, because the police department did something.
So I think he filed a civil lawsuit against law enforcement, and then I think he had a separate bill where they granted him the compensation, where you have to go through the
Right,
legislative
where the
process.
legislature produce a bill for you.
And then to answer your question about representation, I don't know the numbers off the top of my head, but I think my general answer is if you have a private attorney, you're not on death row. For the most part. I think for the most part, the people who are on death row are represented by, capital, I always get this wrong, capital collateral, what is it, Terry?
Capital collateral.
Capital collateral, regional counsel, thank you, which is essentially public defenders in the appellate space for people who are on death row.
But let me just add to that, the reason that there's no private lawyers representing death people, death row, death qualified people, is because they're all poor.
Well,
It's a poverty problem.
But what I was going to add to that is if you, there's a rapper, his name is what is it? YW Melly, yes, that's it, thank you, YW Melly. He is charged with a murder and they are seeking death against him and he has, his trial has been delayed and he has not gotten a death sentence. So I think for the most part, like Terry said, people who are getting themselves in these situations do not have the money to hire private attorneys. The people who do, they don't end up on death row. And what was the other part to your question? I'm sorry.
No,
Oh, one thing I was going to add to that, I will say, a big part to this equation is pro bono attorneys. And I sit on the steering committee for the American Bar Association Death Penalty Representation Project. There are a lot of big law firms out there that are doing this work in this space, and they're partnering with either federal defenders or the public defenders, whether it's CCRC or at the trial level, to contribute to these cases for the reasons that we're talking about, and they're making a difference. If we look at Crossley Green's case, which is a really sad case in Florida, but even, oh my gosh, I can see his face, the case in Oklahoma where he just got released. Thank you, Richard Glossip. He was sentenced to death in Oklahoma. He had, I think, 4 or 5 death warrants, had his last meal several times, and was just granted a new trial. And that had a lot to do by the U.S. Supreme Court after the Attorney General of the state of Arizona agreed he was entitled to relief. And that had a lot to do with pro bono counsel being involved. So there are people out there working on these cases and trying to get the right result.
So excuse my sarcasm, but I'm sure as our president has negotiated with these big law firms to now compensate in terms of all this pro bono, this $100 million or so that these big law is now having to go ahead and deal with the president. I'm sure that's all going to be used to help the individuals on death row.
That was my first question too.
Well, I think what Nichole was going to say was actually that Kenneth Hartley's case is an example where pro bono counsel is partnering with his attorneys and making a difference on his case too. So there are attorneys, private attorneys out there.
And that's why we need the nation and most death row exonerees. We got the great attorneys that are stepping in out there, and we have people such as yourself taking interest in this and voicing our opinions. And, legislation see the difference, judges see the difference, and we're making progress.
But let me say something on behalf of the public defenders. We have a great capital defense system in the Florida Public Defender. We have a steering committee that's brilliant, that's up on the law. We have training that is open to all private attorneys who take court-appointed cases, pro bono lawyers, and it's a gold standard in terms of training. And most public defenders that handle death penalty are better trial level.
Absolutely.
Trial level than
I mean,
private.
the work that capital defense attorneys do, my hat's off to them. It is very difficult work and they do a great job.
Is there any motion to get rid of the death penalty?
In Florida, no, not right now. And they're expanding it and adding to it.
But you
Are
can't
there-
run for Floridians for.
Are there other states that are adding to it as well, or is Florida on the forefront of doing that?
Well, I think the answer to that is yes. Florida sort of started the process in 2023 of expanding capital punishment to non-homicide crimes with our capital sex bill. And then other states have followed suit. At least one other state has enacted a similar bill after Florida did. So the answer to that is yes to both questions.
have any other questions or any from online?
I just wanna vouch that, years ago, I wouldn't say this about the public defender's office, but I have to say, the public defenders these days a lot of them are being mentored by older ones, and no offense.
Yeah.
But the heart they have in these deputy cases nowadays is so tremendous, and a lot of us on death row, when we first get there, we seem like nobody cares about us. We pleading out, nobody hears us. We're crying, nobody hears us. But sometimes we get that public defender that makes a whole big difference in our world on death row.
Thanks for the shout out.
All right, well, I think we're ending this. I don't know how to do that properly, so thank you so much for being here and for your insights and your knowledge and sharing. I appreciate it, and I'm sure everybody else appreciates it so much.
Great.
Let's hear it for Nichole.
Thank you Herman for being here with us, the Tributary. Thank you, all of you, for being here in the room, and to those of us who, or to those of you who have been participating online, thank you for all your great participation. We didn't have any questions, we did have a lot of poll participants and comments. For anybody that missed it tonight, they can go back and check out the replay on YouTube. My name is Deirdre Connor. I'm publisher and CEO of the Tributary, and events like this are made possible thanks to supporters like many of you in this room. So my pitch to you before we leave here today is to share this information, this incredible series of reporting by Nichole and all the work of the Tributary with folks in your network. And if you haven't and would like to consider becoming a supporter of the Tributary, we make it very easy, and you can come talk to me, or you can do so online at jackstrip.org. Thank you all so much for being here, and feel free to stick around and ask more questions of the panelists.
For alternatives to the death penalty, you mentioned it, and they're based in Tallahassee, and they're online. Well, that's Florida. In the United States Supreme Court, first out Florida is definitely statute constitution in 1976. There were only 8 hours, and it was statutory.